Thank you so much, Mr. Chairman. Chris Alexander, I'm the head of Louisiana Citizen Advocacy Group, which perhaps incongruously, in some circles, we're a conservative constitutional advocacy organization throughout the state of Louisiana. And our principal concern is the Constitution and the rule of law. I certainly applaud Governor Landry's desire and effort to stamp out violent crime in the state of Louisiana. We share that commitment. But what we're talking about here is a situation where the legislature is taking upon itself to make blanket rules about when and where and how people who've been convicted of crimes should be granted relief, whether it's parole, in this case, diminution of sentence for good behavior. How is the legislature in a better position to make this determination than a duly constituted parole board that grants a very small percentage of parole in parole cases? The vast majority are denied for very good reason. And the ones that are granted because of particularized facts that apply that make the parole board believe these people are sufficiently rehabilitated. And a very small percentage of them who go through this process return to prison. This is going to work a profound injustice on the criminal justice system because it's going to create great disincentive on the part of people who are trying to improve themselves, become better citizens from ever being able to get out of prison. I am deeply concerned about the effect that this is going to have on the prison population and people who are there who have become different people, but it's because of what they have been through and the struggles they have faced. And to automatically foreclose their opportunity to be released for good behavior, which is all what we're trying to get them to do, is a profound injustice. And it doesn't serve the victims. It doesn't serve the criminal justice system. And I don't know that anyone has put pen to paper here about the enormity of this cost to the taxpayers for the state of Louisiana. You want to talk about being fiscally responsible? This bill is wrong on every single level. And I am a constitutional conservative, and I believe in the rule of law. But let's keep an eye on what the objective is here. And this bill will not achieve that objective. It will achieve just the opposite. And I want to mention to you, Representative Knox, I was listening to you remotely when I was coming in, and I would like to commend you for your astute observations that you made regarding this bill earlier. I share those observations.
Thank you, Mr.
I want to go on
Alexander.
record in opposition to this bill. Thank you.
Thank you, sir. I appreciate that. And I want to touch on something that you mentioned as it relates to this legislature stepping in over the parole and probation board. You mentioned that you're a constitutional attorney, so I'm curious, because I'm not, and I want you to talk to me as if I'm a 2-year-old. I want to try to understand, to the point that you made, how is that even constitutional as it relates to the federal government when there is a empowered parole and probation board in place to make the determinations that we're sitting here talking about now, and then we come in and inject ourselves and say, no, we're going to do that. You, the probation and parole board, we don't want you to do that anymore. How is that even appropriate?
Well, I think, Representative Knox, that one of the dangers of this legislation is I think that by foreclosing the opportunity for good time credits or parole in whatever given case, the bill is vulnerable to a constitutional due process challenge on the part of many defendants throughout the state who are have demonstrated that they are rehabilitated, that they are eligible for parole, and it should be granted. And you're going to have situations where people to whom this law does not apply, because it's prospective only, the people to whom it does apply going forward are going to have a strong equal protection argument under the Constitution. Why is it not being applied retroactively? why is it not being applied to everybody? If it's a good law, why are you not applying it going backwards? Why are you just applying it going forward? I think that there are some due process and equal protection claims at work here. Ultimately, whether they prevail, I don't know. But the fundamental concern that we have is that I don't believe this bill is going to achieve the objective that we're all trying to seek. Does anybody here know the connection between people who have been released for good time on parole based on a decision by the parole board and the massive crime that we have in Louisiana? We all want to clean that up, but by foreclosing the right to parole or good time for people who have been demonstrated by a parole board to be ready to reenter society, what is that doing besides giving them a heart full of despair and hopelessness rather than the hope that they need? And it's not contributing to the reduction of crime at all. That's my point.
Thank you, sir.
Thank you.
Rep. Ventrella.
Hello, Mr. Alexander.
Hello, how are you?
Good to see
It's good
you
to see
here
you
today.
And I know it's a little late, but congratulations on your election.
Oh, thank you. Thank you. I appreciate that. It's good to see you here. So I appreciate your dialogue and I appreciate your points. And I completely understand where you're coming from with some of the parallels. But I can tell you, if you look in the bill, it still does allow discretion by the Department of Corrections. It does allow that for up to the 15%. And again, I can tell you, as I sit here today, I ran for election for these very reasons that we're discussing. I do genuinely want to make a difference, and I do genuinely want to bring change. And I can tell you and everybody listening that I am here with an open mind to keep dialogue going on how we can improve these programs. It does allow under the bill to have discretionary function with the DOC. So we need to make sure that we do have a loud voice of the DOC, that we do want to take these things into consideration. And we're not here just up as a bar, leap everybody in, give nobody a chance. That is not the position I think that this committee is taking. Again, we are genuinely here to try to solve the crime problem. And this is just one tool, one mechanism that we have. So I did want to bring that to your attention and to anybody listening. It does not fully strip away the discretionary function of the DOC, and it does not eliminate good time. What it does is it creates a certainty in sentencing where judges now, as they're going to be hopefully trained in the future, are going to have to look and adjust where they've been sentencing to where they can have a little bit more control over what happens in the future. Now, taking into consideration, there is only going to be a 15% ability of that person to cut down, but it does not completely eliminate as a whole discretion, because it does not eliminate a good time, because I don't think that I could in good conscience vote for that. But here, because there is some assurances with the discretion.
I definitely appreciate your point. Ultimately, the decision would be made by under the current law. Ultimately, the decision is made by the parole board. So really, the overarching question to me is, why is this decision being made by a legislature instead of by a parole board who understands the particularized facts of all these cases and goes through a very comprehensive criteria before they even grant someone a parole hearing, much less grant them parole? So who's in a better position to make this determination in a just and fair way? The legislature, who doesn't know anything about these cases, or the parole board? That's the question. Why are we divesting the parole board that was set up by the state of Louisiana with ultimate knowledge and authority over these cases, and by no means is a liberal bunch of people? It's very conservative. Why are we divesting them of their authority to make these decisions? What's the rationale for that? That's the question. I know it's rhetorical because I'm not allowed to ask questions.
Right. Thank you.
But anyway,
Rep. Bacala.
I appreciate it.
You know, I just think we keep talking about the judges and they adjusting their sentences. I think probably, I don't know, 85% are people in prison are the result of a plea deal. Guessing? That's a guess?
Probably so, yeah, if not higher.
Yeah, so I mean, I think one thing we need to recognize is as a district attorney and a defense attorney are negotiating a plea, I think it actually becomes a back and forth. It's not a judge on a bench. So my client will plead to what it may have been 10 years last year, it might be 5 this year, in order to just have the same sentence. So I mean, we have the resolution that Representative Villio is talking about running, but I think 85% probably of the people who would go to prison by virtue of the plea deal component would probably be serving the same amount of time, and it would not be a question about how long I'm serving, how's it going to be calculated, yada yada. So I just think it's worth noting that we can't just say we have to tell judges, but these attorneys, the defense attorneys, will be well aware of what their plea entails.
I think that's a fair point, Representative Bakala. I just think that, well, the 15% who are convicted and go to prison, 15% of the number of people who are currently incarcerated in Louisiana is a large number, and is going to be very, very expensive for us. That's a big number of
I
people.
don't even know if it's 15%. I'm just pulling numbers out.
Maybe more, maybe less.
But at the same time, I think, again, Representative Villio, let's make sure we recognize that she wants to ensure that judges recognize what the number that they give as a sentence, what it's going to mean yesterday and tomorrow.
Yeah, I do think that judge education is important.